Hello, everyone. Can you hear me?
Yes, good
Yes.
evening.
Okay. So my name is Christiana Longe, and I'll be anchoring the program, the mentorship and internship program for today. So first, I'll be introducing so welcome everyone, welcome our guest mentors and the mentees as well. So first, I'll be introducing what the program is all about. So briefly, JIIPCC mentorship and internship program is a quarterly intellectual property mentorship program for law students, young lawyers, and intellectual property enthusiasts across Africa. Mentees are afforded the opportunity to access intellectual property, advice, training, network, mentorship, internship, discussion, forums, industry updates, and resource materials from experienced IP mentors. This program seeks to intellectual property training, development, evolution in Nigeria, Africa, and around the world. Hashtag JIIPCC mentorship and internship program. You can watch our videos by searching for JIIPCC on YouTube and Facebook. The objectives of the program are to provide easy access to intellectual property guidance, training, and resource materials for students, young lawyers, and IP enthusiasts in Africa, to facilitate dialogue and network among experienced and less experienced intellectual property practitioners and stakeholders, to transform mentees into intellectual property mentors and leaders for the next generation of mentees, to facilitate further intellectual property mentorship, internship, scholarship, and IP-related job placement for the mentees. So we are all welcome to today's section, and I'll be introducing our mentors for today. We have Miss Regina Omeri. I don't know if I got the name correctly. I'm sorry if I didn't. And Mrs.
Regina Omeri.
Okay, thank you very much. And Regina Omeri, yes, thank you. Regina Omeri, she's a senior associate in Aluko and Oyebode. Yes, Aluko and Oyebode, and she has a robust experience in IP prosecution and related practice, gained for years. Regina is the Harvard alumni, and she graduated from the University of Nigeria, Nsukka, with an LLB in 2012 and the Nigerian Law School in 2013. Regina was recently nominated to serve in the International Trademark Association Committee for the 2022 to 2023 term, in addition to being selected as an outstanding trademark and patent practitioner in World Intellectual Property Reports Leaders Guide 2021. Regina is extremely passionate about intellectual property law and policy and how IP affects clients' business. Thank you very much for coming today. You're very much welcome, Regina. And our second mentor for today is Mrs. Eno Ubong Hussein. I'm sorry, if I didn't get your name correctly. Eno Obong Hussein is a principal assistant registrar of trademark, patents and designs, commercial law department, Federal Ministry of Industry and Investment, with over 12 years of experience in the field of intellectual property rights, with focus on patents, industrial designs, and trademarks. She has functioned in various capacities in the trademarks, patents, and designs registry, and gained practical experience handling issues bordering on these subjects. She has facilitated various workshops, seminars at the grassroots level to ensure that the eco-inventing communities are well informed and meaningfully engaged on issues bordering on their intellectual property rights. Some of these workshops had featured strategic collaboration with the World Intellectual Property Organizations and the United States Patent Office. She served as an expert member of the Nigerian delegation to World Intellectual Property Organization at the General Assembly at various times, and on the Standing Committee on the Law of Trademarks, Industrial Design, and Geographical Indication. Presently, she serves as an expert member of the Nigerian delegation to World Intellectual Property Organization, Standing Committee on the Law of Patents. She has also served as a lecturer at the World Intellectual Property Academy, Geneva. Eno Obong Hussein holds an LLB from University of Uyo, Akwa Ibom State, a master's degree in law and policy from the University of Jos, and a master's degree of intellectual property from the University of Turin in conjunction with the World Intellectual Property Academy. She has also trained with the United States Patents and Trademark Office and the Norwegian Patents and Trademarks Academy. She's an alumni of the International Visitor Leadership Program, USA. As part of her passion for intellectual property, she works with Eco Inventing Community on the registration and protection of the intellectual property rights. You are very welcome, Mark, to today's mentorship program. We are very happy to have you. So first we'll be taking the presentations from the mentees, and now we'll be moving to group one to make their presentations. And each group have 6 minutes to present, please. So group one, who's presenting for group one?
Okay, I'm presenting for group one.
Okay, thank you, Adaka.
Okay, Madaka Elogene.
Okay.
And our topic is how innovators in the aviation and the automobile industry use IP. Sorry, the next slide. Sorry, can you move this slide? Okay, thank you. Okay, so as IP has to do with the aviation and automobile industry, we can see that transportation is a pillar of the global economy because it facilitates movement of persons as well as exchange of goods and services. However, we can also see that it also creates avenues for research and development and also predictive modeling. As it has to do with the aviation, sorry, can you move the slide, please? As it has to do with the aviation industry, basically, we will see that the aviation industry encompasses air traveling, and it also comprises of aircraft manufacturing companies, airline companies, which examples could be Air Peace, Airwick, and also flight carriers. As it has to do with the automobile industry, we'll be looking at all activities which span from design, manufacturing, marketing, and selling of motor vehicles. Example could be seen as Honda, Ford, BMW. Okay, when it has to do with IP and the aviation and automobile industry, there's actually a misconception that patent actually is like the only IP rights that deals with this industry. But however, we have various IP rights that deal with this industry. The first I'll be looking at is patents. Patents can be seen as the exclusive rights which grants an invention, which grants monopoly, or which gives someone an exclusive right over an invention. It could be a product or a process patent. The product patent is, however, protecting the product itself. It's protecting the invention, which is the product itself. The process, however, is protecting the process of making this product. And when it has to do with patents, you notice that patent is granted for a period of 20 years, and it could also be for improvement of inventions. As it has to do with patents, there are 3 requirements as it relates to patents, which are novelty, inventive step, and industrial application. Novelty, however, simply means it should be new. It should never be put out in the public before you try to register it. Then inventive step simply means it should not be obvious to someone in that particular field, and it should also be solving a problem which deals with a functionality. Then industrial applicability, simply saying this new invention you have made should be capable of being reproduced. And also when it has to do with patent, because IP rights are territorial, if you are giving patent in one jurisdiction, for you to enjoy protection in that jurisdiction, you actually have to go and register. And the priority period as it relates to patents is 12 months. So before you enjoy protection for your automobile or your aviation invention, you have to have registered it in another jurisdiction within 12 months. Also, we'll talk about utility models. They are seen as a mini patent and they enjoy protection for 10 years. And the requirements are not as stringent as patents. When it has to do with novelty, there has to be novelty, and the inventive step, however, is lower compared to patents. Also, as it relates to the aviation and automobile industry, we have industrial design. Industrial design simply protects the aesthetic or ornamental aspects of this aviation or automobile inventions. What it simply means is protecting the unique shape. So if I have a car that has a very unique shape, industrial design protects this. And some of the requirements for industrial design are it should be new, it should be original. If you are going to look at jurisdictions like Nigeria, they'll provide that it should not be against morality. And also like other IP rights, industrial design is also territorial. So for me to want to enjoy protection over my automobile or my aviation invention, I have to have registered it in another jurisdiction also to enjoy protection in that jurisdiction. And we'll notice that the priority period to register in other countries is 6 months. Then also as it relates to trademark is going to be protecting the unique name or the distinctive sign of my product. So I'll give examples. We have BMW, we have Benz. These are examples of automobile industries which actually have like a brand name that when you call, the first thing you're going to think about would be these brands. Also, it's subject to meeting up with the requirement of being distinctive, not being deceptive, or not being against public morality or generic. We also gave case studies, but I'm just going to list one case study here. And it's seen that in January 2019, BMW filed a design patent lawsuit against Mars Auto for infringing and diluting its trademark and also its industrial design. For them to be able to bring this infringement, they should have registered their design in the other jurisdiction. So that's one of the importance of registering or of identifying your IP rights. Then also the benefits of IP in the aviation and automobile industry. We also talked about other IP rights as it relates to this industry. We talked about copyright. Copyright will come in to protect your original work if they are also fixed. Example, it will protect your software. It could also protect the product brochure of the unique work of any of these industries. Also, trade secrets can also come in to protect how these machines are being made. But for an information to qualify as trade secrets, it actually has to be a secret. You must have taken efforts to protect this information, and it must be an information that is giving you a competitive edge over others. Then also patent also comes in. But however, in order for you to monopolize or enjoy these inventions, you actually have to identify your IP rights first. And when you identify them, you have to register them, because that's the only way you can actually make money from them, because from there you can actually start licensing them and benefit them and enjoy them. So basically that's it. That's it basically. Thank you.
You're muted, Christina.
Thank you very much, Adaka, for the presentation.
Thank
Now
you.
we're moving to group 2.
Okay. Good evening. I'm Judah. You will be presenting for group 2. Just a moment so I can share my screen.
Oh.
Okay. Okay. Can you all see my screen and can you hear me?
Yes. Yes.
All right. Thank you. So
We have 6 minutes.
all right. Noted. I'm presenting on the topic IP for inventors. How can inventors in the communication industry use IP? And our outline here is we'll be discussing what is invention, who are inventors, what is the communication industry and its scope. Then I'll also give examples of notable inventors in the communication industry. We'll go on to what aspects of intellectual property law applies to the communication industry, then legal framework for the protection of IP in the communication industry, how inventors in the communication industry can benefit from the use of IP. We'll discuss briefly the challenges, recommendations, and then conclusion. So we begin with what is invention? In simple words, invention is a new solution to a technical problem, and it can be protected through intellectual property law. One major one, which is patent. We'll discuss other ones later. Then who are inventors? The word inventor it came from the word invenir, which means to find. So an inventor is someone that finds a new solution to a technical problem, finds, creates, discovers an invention, and also solves a technicality. Okay, so what is the communication industry and its scope? The communication industry has to do with
Can we all hear him, or it's just me alone?
No, I can't hear him too.
Okay.
Sounds like he's muted or offline.
I can hear in bits. Skipping.
Jude, can group 3 please present if it's not if it's maybe so that it would work on his network. Olamide, I guess you are the one presenting.
hello.
Yes, I can hear you.
Hello.
Is this Olamide? Yes.
This is Jude, still for group 2. I had network issues.
Okay, please go ahead.
Can I proceed? All right,
Yes.
thank you. I'm so sorry about that. So I was mentioning that basically the communication industry, it covers the telecommunications, mass media, those are the news media, and then social media. I will be restricting our presentation to these three. The communication industry and its scope in Nigeria, we have mainly the telecommunication limited, that is NITEL, Nigerian Postal Services, and other mobile telecommunications such as MTEL. Then the private ones include examples like MTN, the Glo, Etisalat, and the rest. So briefly on some notable inventors in the communication industry. In 1876, Alexander Graham invented the telephone. James Russell in 1970 invented the CD. Mark Zuckerberg in 2004 invented Facebook, which is under the social media. John Charlton in 1861 invented postcard, and several other examples. So what branch of intellectual property law applies to inventors in the communication industry? Basically, this will be covered under two broad groups, which are the formal instruments and the informal instruments. The formal instruments comprises of the enacted laws that protect intellectual property, and this include Copyright Act, the patents, trademarks, industrial designs. While the informal industries, it has to do with the actions that inventors themselves take to protect their own intellectual property. And they comprise of secret complexities in the invention so that persons may not copy them. Okay, so the legal framework for the protection of IP in the communication industry. In Nigeria, basically, we have the Trademarks Act, the Patents and Designs Act, and the Copyright Act. Under the Trademarks Act, logos, images, pictures, symbols, names, signs, colors, and so on can be registered under the Trademarks Act with the Trademarks Registry in order to protect them. Also, under the Nigerian Copyright Act, we use computer programs as an example. They can be protected when they are written, not the application themselves, but when they are in the written form. So this software can be protected under the Copyright Act, while the application themselves are protected as patents. And now this is one of the things that is a legal issue. There is no conclusion as to whether a computer software should be protected strictly under the Copyright Act or under the patents. And then we should note that the formal instruments are not guaranteed by law and are not legally protected. Am I still on? Can you still hear me?
Yes, we can hear you.
Okay, thank you. All right. So how can inventors in the communication industry benefit from the use of IP? It confers on the inventor the legal right to exclude others from using their innovation, and thus addressing the well-known problem of appropriability governing the production of knowledge. Copyright grants the creator of an original work the right to control and use and distribute the work to the exclusion of others. Trademarks grant inventors the ability to set their products apart from those of rivals, reducing customer search, raising incentives to invest in quality and reputation, and increasing the economic returns of the invention. Patents grants temporary monopoly for the exploitation of inventions. Informal instruments of IP are cost-effective and do not entail any application or enforcement costs. However, we should know that informal instruments are not a guarantee. Okay, the challenges of intellectual property law in the communication industry. It applies to every other industry. Generally, there is a lack of awareness by inventors about their intellectual property rights. So they tend to neglect these rights and may not go ahead to enforce them. And also, there's a regulatory gap. One example is the uncertainty as to computer software, whether it should be protected under copyright or patent. Sorry, that's supposed to be patents and not trademark. The opportunities for lawyers. We should understand that every challenge presents an opportunity. So lawyers in the industry should look at the challenges that concern IP in the communication industry and find solutions to them. It also brings room for innovation. Now, one difference of innovation from invention is that invention is entirely new. Innovation must not be new. It can improve on an existing invention. Then research opportunity also for lawyers. Lawyers are to find solutions to problems. So whenever we have challenges, we would not run away from them, but research to find those solutions. There are recommendations. Intellectual property rights awareness education must be made to the general public as to their rights, especially inventors in this particular industry under review. Then enforcement of IP rights. Must all work to enforce these rights and certainty of a legal framework. In conclusion, invention as a process contributes to the technological, social, and economic development of every country. The communication industry facilitates easy circulation of information. It is therefore expedient for inventors in this industry to enjoy intellectual property rights as a reward for their efforts. We believe that this will be achieved if the challenges identified in this presentation and the use of intellectual property in this industry will be well addressed. This is our team, Jude Ayua. I'm the one presenting, HP Gobir, Bethel Inedia, Jeremiah, Mahmoud Reda, and Joy.
Thank you, Jude. Your time
Thank
is
you very
up.
much. Okay,
Thank you. I had issues. I had to strain my eyes to read your presentation. It's quite.
I'm sorry about that.
No, no
sorry
problem.
about that.
Okay, now we'll move to nice presentation. So now we'll move to group 3. Group 3, you can go ahead with your presentation.
Okay, so this is Bumi Akindeko presenting on behalf of Group 3. Our topic is intellectual property for inventors, how inventors in the medical and pharmaceutical industry can use IP. So we began with an insight into what IP in the medical and pharmaceutical industry entails, and we started by saying that the medical and pharmaceutical industry has been described as companies that offer clinical services, manufacture drugs and medical equipment, and provide healthcare-related support services like medical insurance for people in the society. They also provide preventive medical therapeutic services to patients, and as ventures concerned with dealing of drugs and medical facilities, there's essentially a need for these industries to protect the productions that they create. Basically, what this is just trying to say is the description of pharmaceutical industry as we know it by our research in Group 3, they involve companies that render all kinds of medical, pharmaceutical, therapeutic services that involve administering some form of medicine or tools that have to do with medicine to the betterment of the society. And they go through a lot of time, investments of skills. They have to go through a lot of clinical tests, and they have to pass it. So after making all this, they have to make sure that they protect their intellectual property works at all costs. We also said that it is largely recognized that pharmaceutical intellectual property rights are essential for continued innovations of new medicines, and therefore exist in the interest of patients and society at large, just as we had tried to explain earlier. With the need for these drugs being produced, it gives the pharmacists who have the patent, pharmacists and medical personnel who have the patent rights in them, some sort of incentive to keep on creating new medicines. As we all know, one of the greatest statements in the theories of intellectual property law is that it provides some sort of incentive for whoever is producing the work, whether it be in copyright, patent designs, or whatever. So we are trying to say that for pharmaceutical industries, the creation of the protection of these inventions which the inventors make acts as incentive for them to keep on producing more medicines. And if they had not, if they did not have these rights, or their inventions were not protected, it would be a loss for the society, because the pharmacists and the medical personnel would not be encouraged to even make more medicines. Now we talk of patent and medicine. Patents are the foremost means of protection of medical and pharmaceutical products globally. The Oxford Dictionary has defined a patent as a government authority or license conferring a right or title for a set period, especially the sole right to exclude others from making it, using or selling an invention. The exclusive right is granted in return for the investor making his invention publicly known. By this, we try to define the meaning of patents as an exclusive right, exclusive in the sense that it tolerates no other kind of trespass. The owner of a patent is the sole owner, although he can grant some form of license to other people, but owning the patent means that he gets to restrict other people's access to it. Just as we have said, the exclusive right is granted in return for the investor making his invention known publicly. So when an inventor knows that he has a patent on a particular product which he has expended a lot of time and effort and even money on, he's derived some kind of incentive by the patents that is given to him to now bring out his invention for the betterment of the public. A patent provides the legal basis for a commercial monopoly and provided an exclusive monopoly in relation to an innovative product or process. In effect, a patent is a limited property right in which investors exchange for their agreement to share the details of their agreement. Patent law is the branch of intellectual property that protects inventions in products and processes and gives the inventors the exclusive right to the use of invention for a limited period of usually 20 years from the time of filing the applications. Patents are allowed in all fields of technology and incorporated in the laws of most countries. Just like we had earlier said before, patents are granted to inventors for products that they made, and they are not, being that they are exclusive does not mean that they are exclusive forever. In Nigeria, they are limited to a period of 20 years and subject to subsequent renewal. A patent may be granted only for an invention in respect of which the following conditions are satisfied. This is to say that every item cannot be afforded the right of patent. It has to pass the following criteria as I'm about to mention. 1, the invention should be new, that is novelty. It involves an inventive step. It is capable of industrial application, otherwise known as industrial application or utility. Now, if an invention is not new, or if it lacks an inventive step, or it has no industrial application, or the application itself is insufficient, then unfortunately, the patent will not be declared valid by the court, and all rights will be revoked. That is likely to say if it has already been granted that right, and then it is objected in some kind of form. Now, for any new medical device, seeking patent protection should be a high priority, especially as it involves the medical and pharmaceutical industry, which is our topic today. However, there are many things to consider before submitting a patent application to the patent office, such as whether to obtain a prior art search, whether to file a provisional or non-provisional application, and whether there is a benefit to seeking design patent protection. However, the health sector has not leveraged on the existing patent system and health condition, and the health condition of the population is an indication of ineffective patent system in the country. Now, we're saying that there is a need to tackle some of the health problems through a patent system that is very effective and will enhance access to essential life-saving medicines. The next slide, please. Medical device patent search. A prior art search is an important early step in the process of determining whether patent protection is an appropriate avenue of legal protection for a newly invented medical device. Since it is possible for two companies or inventors to arrive at similar products independently without even knowledge of one another, a prior art search performed in advance of fixing a patent application to reveal what other products or prototypes are already in existence is necessary. The results obtained from a prior art search can inform decision-making going forward and can potentially save companies and inventors significant sums of money, since patent claims can be carefully and thoughtfully drafted to extinguish over any identified per act. Now, provisional patents for medical devices in Nigeria and around the world, patent protection is granted to those who are the first to file. This means that the sooner the applicants can file their patent applications, the better. In other words, we can just relate this to being the first come, first serve basic standards. Many applicants elect to start the patent application process with a provisional patent application because provisional filings offer numerous benefits to the applicant. Now, one of the biggest advantages is that a provisional application effectively gives applicants up to a year to begin the patent application process in earnest. Now, in essence, a provisional filing serves as a placeholder in time. It secures an early filing date for the applicant. Please, the next slide. Now, trademarks and the medical industry. Important role of pharmaceutical trademarks. The pharmaceutical trademarks are important because they help consumers find their desired products. We all know that trademarks, just like the name implies, are marks of trades, and they help the public and whoever is looking for a particular product in the market to identify a particular thing that they want, usually because of some kind of personal benefit that it gives to them. Without a strong trademark, it would be impossible for consumers to tell the difference between available products. Pharmaceutical trademarks can also help to reduce the medication errors in the healthcare settings. In addition, a strong trademark helps people to choose correct medications. Trademarks can also incentivize manufacturers to ensure the safety of their existing drugs and invest in new medications. For example, there are different drugs to cure malaria in our society, ranging from Coartem to a whole range of them. Now, people react differently to the different medicines, and a person might just be better with a particular type of drug. Now, because of the trademark, which is like the name, the identity by which you can recognize that drug, it serves as a point mark to that drug, and it's easy for the customer to get what he wants, and it also serves like an incentive for the manufacturer, knowing that this product is desired by the population and he can make more of it, help the society, and also gain. Please, the next slide. Now we'll go to types of intellectual property in the medical and pharmaceutical industry and their duration. Now, we've talked a lot about patents, but this is not to say that patents are the only type of intellectual property rights that are available to inventors in the medical and pharmaceutical industry. And in an attempt to explain how different other type of intellectual property rights can accrue from works of medicine and pharmacies and pharmaceutical works, we have created an image that depicts everything we are going to explain. Before us is an image of two boxes of paracetamol tablets created by the pharmaceutical company Emzor. The next slide, please.
Wumi, you're out of time, please. Just round up, please.
Okay, so we are just trying to explain with the boxes of medicines that the name accrues for trademarks because it is the name Emzor and the design on it because it is an identification of the medicine. The leaflet that usually comes with the box is afforded copyright because it is part of literary works under the Copyright Act. The designs by which the medicine is encapsulated in the foil serves as industrial designs because it is a type of design different from other types of design by which medicines are encapsulated. So we try to explain how different intellectual property rights can accrue from pharmaceutical and medical patents. So in all, we have tried to summarize from our research in group 3 that medical inventors and pharmaceutical inventors can benefit a lot from knowing significantly how to use their intellectual property rights and how intellectual property rights in the works that they produce. And we can all do better if we put more intention into knowing how these things work. Thank you.
All right, thank you very much, Bumi, for the presentation. So now we are going to move to group 4.
Good evening, everyone.
Good evening.
My name is Sandra Nweli, and I'll be representing Group 4. So we'll be looking at IP for inventors with particular reference to the engineering industry. Okay, before the slide comes on, we know that in the society, there are a lot of challenges in the society, a lot of problems, and so there must be solutions to these problems. So people that provide solutions to these problems are called inventors. So that's what we'll be basically looking at, and then with specific reference to the engineering industry, how the engineering industry has particularly solved the issues in the society and the intellectual property rights that accrue to them. I don't know if the person with
Amaka?
Okay, sorry, I'm trying to share my screen. I don't know.
Why not continue with the presentation? I'm sharing the screen already.
Okay.
I'm sharing the screen already.
Okay, thank you. Thank you very much. Let's go to the next slide. Okay, so like I was saying, I said we'll be looking at who inventors are, how inventors need IP rights, what intellectual property rights that the people in the engineering industry can leverage on. Then we'll be looking at a case study and we'll conclude. So let's look at who inventors are. Next slide, please. Like I said previously, the problems that the society experiences necessitate the capacity of people who can solve such challenges or problems. And so inventors are individuals that discover new ways of doing things to create technology that improves our lifestyle. Inventors are those who produce useful and new products or process. They also make improvements on existing products or processes for the betterment of the public. Inventors are innovators who through their inventions have provided solutions to the problems of man. These inventors can be individuals or corporate bodies in research and development departments. Now, the engineering industry is one of those industries or one of those particular specific industry that provides solution. So through their invention, they provide solution to the problems that humans face in the society. So our task for the group really is to talk about how these inventors in the engineering society provide solution and the IP rights that accrues to them. Next slide, please. So an example of an inventor is Thomas Edison. He lived between February 11, 1847 to October 18, 1931. I'm sure most of us would know him or would have heard of him. Thomas Edison is probably the most famous inventor for being the inventor of the light bulb. But over the years, he has invented other things, plenty things that we use today in the society. He invented something like the motion picture camera and even the phonograph. Next slide, please. So let's look at the engineering industry. Like I said, the engineering industry is really pivotal to human existence. This is because of the major role they play in providing solutions in terms of invention to solve human problems. Engineers are professionals. They are professional innovators who work in the realm of industrial property and are often the first, and they are involved in creating proprietary design or invention that solve the problems, or basically they provide new things, they create ideas that solve problems. And we have different sectors in the engineering industry. We have the mechanical engineering, software engineering, electrical engineering, civil engineering, chemical engineering, and the architecture. I don't know, every day we come across something that points to engineering. It shows that they go a long way, or they are very pivotal to our existence in the society. Next slide. So why do inventors need intellectual property rights? Now, one of the reasons, like we've heard in our previous classes, is to grant exclusive rights so that the inventor can recoup the investment of his inventive faculty that he in making such products or processes, and also, secondly, to be recognized as the brain behind the invention. Of course, it would be good that someone is providing solution to a particular problem. It would be so nice to give him an applaud or an accolade to encourage him for the work he has done. Now, with particular reference to patents, once inventors have patent protection, they can make money by being the only one allowed to produce, distribute, and sell these inventions. Most times, we find out that some inventors are too busy working on their next idea that they don't even have time to sell their previous invention. Most times what they do is that they prefer to license this invention so that they can make money from their ideas or the problem or the solution that they created. The next one says that it affords them the right to seek enforcement in cases of infringement, and finally, to prevent others from trespassing and taking unfair advantage of his inventive labor. Next slide, please. Okay, so we'll be looking at the intellectual property rights that inventors in the engineering industry can leverage on. Now, there are some of the rights that these engineers in their industry, some of the rights they can leverage on are patents, trade secrets, industrial design, and trademark. I'll be briefly looking at these rights like we know them already. Next slide, please. Now, patents. According to the World Intellectual Property Organization, a patent is a document issued upon application by a government office or a regional office acting for several countries, which describes an invention and creates a legal situation in which the patented invention can normally be exploited, i.e. manufactured, used, sold, or imported with the authorization of the owner. Now, when a patent is used to protect an invention, the act of patenting it makes it a private property so that only the owner can control its sales or its distribution. In some respects, we can compare a patent to those of a title deed of a piece of land. A patent confers on its owner a legal right, as in the case of a land, to stop all others from trespassing on the invention, just like the owner of a piece of land has the right to stop trespassers using or occupying his land. However, before an inventor of a machine or a product or a process can validly own a patent, there are requirements that such inventions must fulfill, even when the invention is an improvement on an existing invention. And some of the requirements include that the invention must be new, it must involve an inventive activity, i.e. the steps involved in making the invention must not be obvious to a person skilled in that area of engineering. And 3, that the invention must be technically functional or industrially applicable. Next slide, please. Now, a striking feature about patent is that which is peculiar to invention, is that it's not automatic. What it means is that you don't just get you don't just get the patent intellectual right because you have a new idea. It means that you have a great responsibility to understand or identify a particular intellectual property right in your invention so that you can enjoy the benefits that accrue from them. So it means that those inventors or innovators in the engineering industry, they must take proper care to understand the intellectual property rights, if it is patent or other rights that we'll later look at, to understand it so that they can get registration or get the proper protection they need, because it doesn't just come automatic. Now we have examples of engineering inventions. We have the quad copper drum. It was first patented back in 1962 to Edward G. Van der Riep. And then the United States Patent Office issued patent number 3043625 to Niels Bohem, a Swedish engineer, for a 3-point safety belt designed for use in road cars. Next slide. I think our next slide shows us the examples that I just mentioned, the quad copper and the 3-point safety seat belts for road cars. Next slide, please. Now, another intellectual property rights that inventors in the engineering industry can leverage on is the trade secret. Is a trade secret. Trade secret is conferred upon secrecy or non-disclosure of formula, know-how, or vital information / processes. Unlike patent, like we know, patent may be known to the public. Patent may be known to the public, but trade secrets requires that the process should be kept secret or confidential. In any clause of disclosure to a third party, the owner must ensure that a non-disclosure agreement is entered into between parties. Now, like I said before, unlike patent that requires the disclosure of the work, the process of the formula, or the technical know-how, which allows the public to have access to such information, trade secrets, on the other hand, allows for the contrary, in the sense that once the information or the process goes into the public domain, an engineer or an inventor cannot leverage on the trade secrets right as an IP right. Next slide. Industrial design. Like we learned in our last class or in our previous classes, industrial design, what it does is that it protects the outward appearance or aesthetic or the cosmetic appearance of a product. Now, when there are so many machines doing the same work or performing similar function, industrial design can be used by an engineering company to create branding and market value of such products. Since industrial design protects design or pattern that are aesthetic and involves an outward appearance, when engineering industries, when they make products, they have to
Okay,
take
we pass your allotted time, please. Just briefly.
Okay. Such outward design of the products can be protected. Now, what's industrial design? Most times we know that we cannot really talk about the commerciality of an intellectual property right using patents or some other design. But now, what industrial design means, or getting protected under the subtopic industrial design, is that you're going to gain money or you get branding and everything under it very well. For the sake of time, let's look at a case study so that I'll just conclude. Next slide. Let's look at the case study of English towards the end. Okay, so there's a company, it's a Moroccan company, was founded in 1975. Now, this company is one of the major international players in this industry. It designs, manufactures, and sells a lot of electrical equipment such as switches. That means they are innovators in that particular country. But we know that this particular, why this company is very pivotal to our presentation today is that what they are not so much about their buildings or the structures they have. What they want is that the company strongly believes that through IP, it can communicate the quality of its product with consumers, which increases the product's value and fosters production. So the company has registered its design since 1976, and in 2010, it made 6 new registration. In line with the English IP strategy, it's also applied for trademark registration with JIIPCC. As of 2020, the company has registered over 49 domestic trademarks, which includes its name and its logo. I will end by saying that intellectual property rights abound, but inventors or innovators in the engineering industry would not really know these rights or will not enjoy the benefits that accrue to them unless they recognize or do a proper study on the intellectual property rights that accrue to them and take the necessary step to get themselves protected. Thank you very much.
Thank you very much, Sandra. Thank you for that beautiful presentation and everyone that has already presented. Please, let's hear from group 5.
Okay, group 5.
Good evening, ma. Good evening, everybody.
Good evening.
This is Oluyede Victoria presenting for group 5. Please, 1 minute, let me share my screen. 1 minute, please.
Can you be presenting, please, while you share your screen?
Okay. We're talking on inventions, IP for inventors, and we are focusing on how can inventors in the virtual reality industry use IP. So basically, we've been talking about inventions since we started, and invention is the inventors are the persons that produces or creates or finds anything that benefits the society. Inventors for the first time, possibly, and most especially technologies and all that. And virtual reality, defined by Wikipedia, defines it virtual reality as a stimulated experience that can be similar to or completely different from the real world. Virtual reality takes whosoever is using the device, the VR, at that point takes the person from the world entirely. The person is in a different world. Like there's a complete immersion. The person's senses, the total senses, they're seeing different things. It's a computer created environment that creates scenes and objects, and the person is transported from the real world to a kind of unrealistic, but it makes it realistic that the person is literally seeing it, but the person is oblivious to his environment. Please, can everybody hear me?
Yes.
Okay, so virtual reality is the use of computer technology to create a stimulated environment. Human beings are visual creators, and display technology is often the biggest difference between immersive virtual reality system and traditional user interface. Unlike traditional user interfaces, VR places the user inside an experience instead of viewing a screen before them. Users are immersed and able to interact with the 3D world by stimulating as many senses as possible, such as vision, hearing, touch, and all that. Like I explained before, it's just a totally different world that the person is immersed in. So virtual reality has led to the development of considerable IP issues and several other legal ramifications. The use of IP in the virtual world can end up being a major cause of concern for IP owners. Several games displays the trademark of third parties to I'm having issues seeing this. I'm sorry. Parties to create a realistic experience for their users, as well as allow players to purchase merchandise, exchange virtual cash for real cash, export images, music, brand names, etc., which could violate intellectual property rights, IP rights, especially trademark and copyrights of various brands existing in the real world. Now, this is saying that even though virtual reality is an invention, most times they import or incorporate into their virtual experiences, let's say music, photographs, things from the real world. And we can see that in so doing, they are actually infringing on the intellectual property of the persons in the real world. Sometimes it's hard to actually tell who owns the intellectual property, because they are using things from the real world that persons already protected, and because they are the one giving, it's actually quite hard to differentiate, but we are going to point out the ones that we can use and the disadvantages that has been in using them though. However, inventors of virtual reality can make use of intellectual property just as it relates to their inventions, such as copyrights, trademark, and patents. 1 minute, please. Trademark and patents. So we want to talk about how can inventors in the virtual reality and industrial use IP. We want to talk about the rights that they've been using. Copyrights. Yeah. Computer software can be granted protection as a copyright and this can lead to disputes over the ownership of the copyright in the software. Now, one of the most noted cases in this regard was the ZeniMax case against Oculus VR, where Oculus was directed to pay some amount of money, amongst others, for a certain amount of money, amongst others, for copyright infringement. But the case was later settled out of court. The thing was that Oculus made use in their VR of certain things that belongs to ZeniMax, and they were charged to court. They later settled the matter out of court anyways. The lawsuit involved the theft of ZeniMax computer code and proprietary information that was used to develop Oculus product, that is VR. Now, protecting patents. This, within the VR, oh Lord. 1 minute, please. So, can hardly see this. 1 minute, please, sorry. Patents within the VR space go back as far as 1993, when a patent for a virtual reality image was first filed. Although, depending on how you're defining VR, it could be argued that the first patent was filed in 1961. Now, many companies are filing patents now and have been filing patents to protect the technology behind headsets and hardwares, the VR headsets and hardwares development. Although it's worth noting that patents can take a very long time to process. It can take a very long time to receive protection for new technology. For example, 2 Oculus patents originally filed in 2016 were just published online in 2018. So even though there is patent protection for the VR, just the same way patent has issues for protecting intellectual property of persons in the real world, it also has the same issues in the virtual reality. So the patents originally filed in 2016 were just published online in 2018 for a haptic VR glove service. Apple also filed a patent. I can't see the rest of that, but Apple also filed a patent. Now we'll talk about the protecting trademarks. Now, in an attempt to create a realistic experience for the user developers or users, often based the virtual world on the real world, and in this regard, end up using trademarks in the virtual world of various proprietors from the real world. I think I said this already. There are actually music of other persons, photographs, other things that it could be are incorporated into this virtual reality and thus infringing the person's intellectual property, although it depends on the nature of their use and of the IP owners that would determine whether they actually infringe on the rights on the intellectual property of the persons from the real world. But importantly, there are not good tools for this yet. Usage is not tantamount to infringement, as I said, as some uses can be fair use, although there have been many debates within the entertainment industry, especially cinema law, for many years, whether and how VR providers will begin selling items within a VR world featuring items bearing a third-party trademark is yet to be determined. Yeah, sorry. So I'm concluding, there are no specific laws regarding VR yet, virtual reality, but existing IP laws are still applicable for the same, like we've mentioned, the copyright, the trademark, and patents. Applicable for the same, since internet reality is soon going to be the norm. The existing laws should be construed to develop good practices and balance the interests of the parties. Laws should be interpreted in a manner which foster the development of VR as well as safeguard the interests and rights of the IP holders. So the laws should be interpreted in a manner that will balance the interests of the VR holders, the VR inventors.
Thank you very much for the presentation.
Okay.
Thank you very much, Group 5. Thank you very much, Group 1, Group 2, Group 3, Group 4, Group 5. So now we'll be moving to our mentors presentation. So I'll be calling on Regina Nwomere to make our presentations.
I thought it was supposed to be a top.
Yes, you comment on their presentations.
All right, thank you. So let me just start with a quote. I found this quote very interesting. It says that the progress and development of man essentially depends on invention. The most important product of creative mind is the invention. So this highlights how important invention is for man. And it's not in doubt that patent is currently the, let's say, the most important form of protection for invention. Yes, the mentees have actually done justice to the topic, and they've already said that they have already told us what invention is and what patent is. I'm sure that they can say it from their sleep. Because if you wake them up tomorrow, they can already tell you what invention is and what patent is. And the mentees have discussed patents and engineering, patents and automobile, communication industry, medical, pharmaceutical industry, discussing the major categories of IP rights in Nigeria, which are patents, trademark, industrial design. They also mentioned copyright and trade secrets. So while going through the presentation, I noted a number of things. Patent is usually for 20 years, which they rightly said, but there was a group that for design, it was stated that it was for 25 years. I'll get to that. So patent is for 20 years, as we know already. And it's renewable annually, that is every year. In Nigeria, it's expected to have, you are expected to have renewed your patent at least 6 months from the due date. Then from group one's presentation, from the slides, I noted that Nigeria was listed amongst one of the countries for utility model. Yes, utility model is now recognized at the Patents Registry, but we understand that there's still no legislation, there's still no law in place. The patents and designs, the Honorable Registrar had intimated stakeholders that there will be a regulation in place, but we're yet to get that. So there's still a lot of, I thank God that Bryce I know is here. She's going to speak to that. But for utility model right now, there's still no regulation, as far as I know, in Nigeria. And then in one of the slides too and presentation, I noticed that it was stated that IP rights are territorial, which is correct. And then patents are protected internationally. Yes, it's true. Through the PCT, you can protect patents, but you have to designate different countries. If you designate Nigeria, for instance, you would have to file that patent in Nigeria. So it's not that you file at WIPO and then you are protected worldwide. You still have to file within the designated jurisdictions within a particular time period, say 18 months or 30 months, as the case may be. And then I also noted that a number of us mentioned trade secrets. Yes, trade secrets is a very important aspect of IP, particularly in regards to innovation and invention. It's very important, provided information is kept secret. The reason why trade secrets is really very valuable is that, unlike patents, you have to disclose your invention in details, and then it's protected for a limited time period. But for trade secrets, provided that the secret is kept really secret, there's no time frame, it's protected forever. Then from group 3, slide 9, I noticed that it was stated that, yes, patent is granted as in respect to those that are first to file. And then I wanted to also add that it is first to file or first to claim priority. Priority here, it could be PCT or from a convention country. So there are convention countries which, as a Nigerian and you're filing at the patent registry, you're required to file within 12 months. If you're filing a convention patent, then we understand that if you're filing a PCT patent, it's within 30 months or 18 months, as the case may be. So if you're claiming priority, your rights start counting from the priority date. But if there's no priority, it will be from the filing date. Then from the same group 3, slide 12, I noticed that it was stated that design is for 25 years. That's not for Nigeria. That could be for other countries, say India or other countries, other jurisdictions. But for Nigeria, design is for 15 years. It's renewable every 5 years from the filing date. Then from group 3 also, I noticed a pharmaceutical trademark. It's kind of ambiguous because in the arts and in practice, I don't know that there's pharmaceutical trademark. So you can say trademark is trademark, and then trademark is classified in different classes. So for pharmaceutical products, it's basically classes. The most important is class 5. Then you could ask who's in class 3, that's for products. So the pharmaceutical trademark is kind of ambiguous. Yes, that's my comment. I don't know. I also wanted to ask mentees a question. I understand that some people see patents as very boring. I don't know, in the course of preparing for this presentation, did any of you see patents as a boring subject matter?
So anybody can answer. You can just unmute yourself and answer.
Okay, this is Jude. All for me, I don't see it as such, and even during the research, I didn't see it as such, though it's somehow a bit technical than the other aspects of IP. But then,
right, thank you. Thank you. And some also see it as very abstract, as in it doesn't relate to your day-to-day activity, as you see trademark and other forms of IP. So that's my comment. I don't know if I should go to the questions that were sent, or I should just wait for answer now.
No,
Yes.
you have to wait for the next mentor to.
Right.
Mentor too. Yes.
Right,
Thank you very much, Regina.
Thank you, Ma.
You're welcome.
So now I'll be inviting Mrs. Eno for our comments.
Thank you very much. And thank you for all the speakers, or thank you to all the speakers for their speeches. It looks like they were well researched, so you did a thorough job. Well done to all of you. Well, I listened with so much interest in the topic that we dealt with, and I think it was well dealt with. But I more or less really looked at the structure of the speech. For the first speaker that spoke about the aviation industry, I noticed that when you started your speech, it just went straight. You didn't let us know the objective of the speech. I thought it could have been better if you had at least let us know the objective of the speech. But however, you did a good job. For your visual, I thought you used a lot of words instead of graphics. Perhaps too, you could also work on using more graphics so that the audience could be able to connect better with your speech. You had so much words on your presentation. And I think this also cuts across other speakers too. Perhaps too, if you could bring in more graphics to illustrate your point, it would help you not to be reading from the slides, because it looked like you were reading from the slides. Reading from the slides could give your audience an impression that you don't have a full grasp of the topic, whereas you actually do have it. So maybe you could also focus on working on that for your next presentation. For your vocal variety, I would say it was good, but I would like to comment on your tone, your volume, and perhaps to your, the tone and the volume. For the tone, I noticed that most speakers just maintain a monotone. You didn't kind of use modulation that could place emphasis on some certain points, perhaps because most of you tend to be reading from the slides. And then the volume was okay, maybe because it's like a virtual meeting. Perhaps if it was a physical meeting, you could have been able to use that better. Then I will talk about the comfort level. For the comfort level, I thought the speeches were well prepared. You seem to all know more or a lot about what you were talking about, which was also good. But for the first speaker, I noticed that he ended by saying that is the basic thing. I think that word is not really, but it's not really did not really sound well at the end of your speech. You started very well, you took us through the aviation industry and the overlap with IP. But when you ended, like you just dropped us to the bottom without giving us like a soft landing. I thought perhaps you would have ended by giving a summary of what, you know, by summarizing your thoughts, maybe in 1 or 2 sentences. That would have at least been better. For group two, you talked about, was it engineering? Okay, for group two, the speaker did a great job, but I noticed that the speaker used a lot of short words. I noticed the speaker kept saying and all that. So perhaps you could also work on that to enhance your, you know, your speech. Because sometimes when you use a lot of such clutch words, it gives the impression that perhaps you don't really know a lot about your speeches, but maybe you could have worked on that better. I also want to say that you could have also used, when you talked about Alexander Graham, maybe you would have given us a visual, a picture of him, so that we could connect better with what you were saying. However, you didn't do that. So please, maybe you will improve upon that. For group three, you talked about intellectual property for inventors in the pharmaceutical industry. I think that was really, really interesting. I listened to it very well, and I think it was really, really interesting. But I noticed that you were almost running out of breath. Maybe you were a bit too fast, maybe because of the time. I also noticed that your presentation had too much words on the slides. So perhaps you could work on reducing that. And also, given the time, you were given 6 minutes. And we believe that you would have been going through this presentation before now. So maybe next time, when after writing your speech, you could time yourself to ensure that you are within the time, that's the time given to you by the moderator, so that it could help the moderator to also do a better job at coordinating the meeting. Otherwise, I think you did very well. And your summary was also good. At the end of your presentation, you were able to give us a summary of your thoughts. You talked about trademarks, or you started with patents, took us through trademarks. And I think that was also very good. Then for group 4, we talked about IP for engineering. You did a good job as well. But then I think you also had the issue of time. Time is always of essence. So you also need to be a little more conscious whenever you are giving a speech with regards to your time. For group 5, group 5. Well, I think everybody did a great job, and you could also improve on what you have given us now, maybe your next presentation, because as a lawyer, even if you are not a lawyer, irrespective of the field of industry that you are in, you will always be called upon to speak, and you want to speak in such a way that your audience will appreciate your thoughts and also be able to follow through, and then we'll even invite you for other platforms in future. Thank you.
Thank you very much, Ma. Thank you very much, Ma, for the comments. Thank you. I would have wanted you to also comment on my introductory speech as well, but you didn't.
On your what?
My introductory speech. So we'll now be moving to the questions, and I've written them down I've typed them on the chat box. So any of the mentors can just comment on any of the questions, or if you want me to read them out, I can do that.
I think that you can just read them out.
Okay. So the first question is, does the international registration via patent cooperative treaty extend to utility models? That's the first question.
You can read all.
Okay, then the second question is, can methods for surgeries be patented? Can the government prevent monopoly, especially if life-saving medicine and vaccines are involved? How does the emergence of the blockchain technology affect the communication industry? How can lawyers maximize the opportunities in the emerging technologies affecting the communication industry? Those are the questions.
Okay. So if I'm to, I think I can contribute to the first, I can answer the first one that has to do with international registration via the PCT, extending to utility models. Utility models are actually patents, and also business method. Actually, it's supposed to be utility model patents and business method patents. So the only difference there is that while patent is 20 years, subject to paying your renewal fees yearly, utility model is granted for 8 years, and business method is granted for 5 years. The same number, the different number of years, but the same fees also apply and the same laws also apply. So when somebody files via PCT, it's presumed that the person has filed in the parent country already and is just using the PCT route to be able to file in different other countries. So when the application comes to Nigeria, if we look at it and in the strict sense of it, we cannot grant a patent right to it. We will ask the applicant or his agents to go for either utility model or business method patent. So technically speaking, you could say that it extends to PCT applications as well.
Thank you very much, Ma. So we can also hear from Regina.
Yes, thank you very much, Barcelona. Just to add to what Barcelona has said, utility model patents, as she has said, is available under the PCT. And before you can file it there, you have to first of all confirm that the countries you'll be designating also have utility models in their laws.
So if I'm to add to what Regina has said, that you filed a patent in a particular country, maybe you are a national of, maybe you are from US and you've validly obtained a patent in US, is not a criteria or a must that you would be given the same patent in Nigeria, because our laws may not strictly be the same. So a patent filed in US, you may come to file in Nigeria, even if you are coming via the PCT route, and you are advised to go for a utility model or business method patent.
Okay, thank you. Thank you very much, Ma. Thank you everyone for making this day a remarkable day. Thank you, Christina, for an amazing...
Mr. Ayokle is here. Can we, if you have anything to say?
Yes.
Can we sorry, how about the other questions? Are we moving on with them?
Yes, yes. You can also touch them.
Okay, let me just touch one or two. The question from group 3 about can methods for surgeries be patented? And the other one on can government prevent monopoly, especially if it's life-saving? So my thought on that would be that yes, government can prevent. So under the Act, yes, under the Patents and Designs Act, government can, under the umbrella of public health, decide that a particular invention cannot be monopolized. That by that I mean that they grant compulsory licenses to other individuals to use the patent to market, to sell, to produce, to manufacture, and in some instances to also import, but generally you are prevented from importing if you are granted a compulsory license. But if for certain conditions and other certain rules, you could be allowed to import. A vivid example is the current issue we have now with the COVID-19, the vaccine. Certain jurisdictions, as you know, have granted compulsory license to individuals to produce these vaccines and related gadgets for control of COVID-19. We are not aware that there is such in Nigeria yet, but we know that in the future there could be. So government has the powers under the laws to do that. Then the question under group 3, can methods for surgeries
I can't seem to hear her. Can anybody hear her? Hello?
No, we can't hear her either.
Okay. So I'll just call in the other mentors that are present. I can see Mr. Ayokunle Adetula and Mr. Folari. Any of them can just say hi to us. Thank you very much.
Mr. Christian here.
Okay.
Hi, everyone. I apologize, Juliana. We're preparing for the conference, which is coming up, the MBA conference, which started already in Port Harcourt. So, hello, everybody, virtually from Port Harcourt. How's everybody doing? I'm glad to have joined. I caught Barrister Eno of the fantastic Barrister Eno. Good evening, ma. I think the conversation. Good evening, ma. I'm not calmed up, so I'm not sure if you remember Michelle. But today's conversation, I think, has been a very interesting one. We had the conversation during the week on fintech industry, and people were also asking questions about design patents, utility models, business methods. And I don't think in this part of the world you can find anybody who is stronger on that subject than Barrister Eno, especially with regards to modern trends and developments. So, fantastic one, Juliana. Well done, everybody. Good evening once again. Sorry for joining late. I do wish everybody a fantastic weekend ahead. Thank you very much.
Thank you, sir.
Thank you, sir. So Mr. Ayokunle or Mr. Christian can just come in.
Good evening, everybody.
Good evening, sir.
Okay, so I think I've joined the discussion from scratch, and the groups did well, and I mean they've gotten the necessary touch-ups from my colleague and Mrs. Eno, and I think that actually puts them in a good footing to be able to at least touch up on the areas that they have not probably put out their best efforts. It's good to be here again after a while, and
we missed you.
and I hope that people will take advantage of this opportunity. The mentees will take advantage of these opportunities and equip themselves. Thank you very much.
Thank you, sir.
Thank you very much, sir. So now I'll be calling on Mr. Christian Aniku.
Maybe he's not on seat, so so I don't know if Mrs. Eno wants to say something before we round up. Ma, you're muted.
I actually wanted to talk about the surgical method, but I think we are out of time. But I just wanted to say, though in the strict sense of it, it is not an enforceable right, because the government would not want technology to be stifled. And you know how important the healthcare industry or the healthcare industry and medical industry is to the country. However, some inventors still insist on having some form of protection, not because they want to exercise the rights to exclude every other person from the invention as is with the patent right, but just because they want to have some form of recognition, and they also want to take advantage of the signaling effect of patent so that other people would know that they have come up with something like this and perhaps help to publicize their invention. So in the strict sense of it, surgical method patents are not patentable, or inventions are not patentable. Thank you.
Thank you, Ma.
Thank you. Okay, thank you very much, Ma. Thank you for today. Thank you, Christina, for the moderation. Thank you, Mrs. Eno. Thank you, Regina. Thank you, Mr. Kristen. Thank you, Mr. Ayokunle. Thank you, Mr. Folari. Thank you all. Thank you to all the mentees that have stayed till the end, and special thanks to the mentees that put their video on, and to those who presented and those who shared their screens, and to those who did the background research and everything. We will not be here without you. You have made this presentation and this whole session possible. So thank you so much. We are going to be seeing next week, Friday, and we'll be discussing AI, blockchain, and all the techie stuff. So I'm hoping to see everyone here next week, Friday. Thank you so much, and have an amazing weekend, everyone. Bye.
Bye.
Thank you. Bye.
Thank you.